Could the word arson have tainted the entire case against a businesswoman? Susan Lukjan's defense team suggests it created a bias in investigators and now wants them dismissed. WLKY's Ann Bowden is live at the Judicial Center to tell us all about it. Ann?
Well, Vicki, Suzanne Lukjan's lawyers say that the fire investigators who were responsible for finding the cause and origin of that fire had heard the word arson before they even started investigating, making them biased and unreliable. But the Commonwealth says those fire investigators are just fine, and this is just a tactic.
The methodology they used was unreliable, leading to unreliable conclusions.
If you didn't know anything about the scientific method of arson investigation, you learned about it Monday afternoon in Judge Fred Cowan's courtroom. It's that method of finding the origin and cause of a fire that the defense says was flawed in the Susan Lukjan case.
What we're trying to establish is that the experts for the prosecution did not follow the scientific method, which under applicable publications they're supposed to do.
Attorney Thomas Clay claimed the Commonwealth's expert witnesses heard the word arson before they even started investigating the fire back in 2006, causing them to become biased and unreliable in her first trial. A jury convicted Lukjan of setting her St. Matthew's business, Campbell's Gourmet Cottage, on fire to collect insurance money. She served 6 months of a 12-year prison sentence before the State Court of Appeals overturned that conviction. A second trial date has been set for September, and the Commonwealth wants to use the same expert testimony. But the defense wants them gone for trial number 2. That's including the ATF, electricians, and arson investigators.
We're saying that all experts presented by the prosecution, all their testimony and their conclusions should be excluded because they failed to follow the scientific method required.
You know, bias is something that's thrown at every police officer, every expert, every person that's ever been called to testify by the Commonwealth. It's a common defense tactic, and they are certainly entitled to argue it.
The Commonwealth says their experts weren't biased, but instead used their years of experience to come to a reliable conclusion.
And I think what's in the record and what's been shown is that our experts have over 100 years of experience.
Now that argument between the Commonwealth and the defense has not finished. They didn't finish today. They will continue that argument in early September, just a few weeks before Lukjan's trial is set to begin. Reporting live outside the Judicial Center in Bowden, WLKY News.